Hi, everybody. Happy St. Patrick's Day. I'm Samantha from the law offices of Samantha Wolfe, and we're located at 20 East 6th Street in Suite 206 in Waynesboro. You can reach us at 717-655-2676. And we do offer consultations, and you're welcome to call and schedule that at any time. So welcome to our monthly virtual seminar. Thanks for being on today. As you can see, I'm celebrating St. Patrick's Day. I have to admit that I did not wear green today. So Tammy very thoughtfully had brought this lovely headpiece. So I'm sporting it in honor of St. Patrick's Day. So I will take it off when I start actually presenting, just so it doesn't distract everybody. But I wanted to spread a little bit of joy on this Wednesday. So happy St. Patrick's Day. With that, I'm going to go ahead and share my screen and we're going to get started. So let me do that. All right. Okay. I'm going to take off my headpiece here. Okay. So like I said, welcome to the law offices of Samantha Wolfe. I have our mission statement here. We just like to include that as part of our presentation. And then I do have some exciting news. We're working on our website. We're working really hard to get that going. I know it's been a little bit since we started the office, so we wanted to make sure we had an online presence. And as part of that, I can share this with you. This is our logo that will be displayed on our website. So I got to see a mock or a draft form of what the website will look like. So I'm excited to be able to share that with everybody. And we will make sure to post it on all of our social media platforms when it actually goes live. Today, we're talking about keeping it green, which I think is appropriate since today is St. Patrick's Day. So I wanted to focus specifically on farms. I felt like with it being springtime, St. Patrick's Day, there's just so much green that we're going to be seeing, well, hopefully. I know it's still a little brown out there. So today we're going to talk about family farms and how we can help plan for them. And I wanted to share a little bit personally. This is a subject that does resonate with me a lot personally. My dad grew up on a farm and will always be a farmer at heart. And this is a picture of the farm where he grew up in Emmitsburg, Maryland. So whenever I have the opportunity to help family farms or help farmers with their estate planning, it always just hits a little bit closer to home. I feel a little bit more personally involved, I guess, coming from a farming family. So I wanted to share that background. This was taken probably a little bit later in the spring. It was probably, May before this was taken. Things are a little bit greener than they are now. So this was a few years ago. So you can bet the farm on it. My goal today is I want to share some tips and some information for farming families. And this can apply to small businesses as well. So it can apply to farms and businesses. And the way I like to look at it is that farms are one of the most successful small businesses that we have in our surrounding area. And just having a farmer as a dad and being part of a farming family, I can say that my dad is probably one of the most intelligent people that I know. And he's not college educated, he just has his high school diploma. And so I wanted to try to give helpful tips to farmers and then also give them a springboard for additional planning that they can do once they have everything in place at the foundational level. So that's what we're going to discuss today. I will take questions at the end. We usually stop recording and then I can either take them verbally if you want to jump on the video, or you can always put it in the chat box as well. So we're going to start at the beginning, which is a very good place to start. So whenever we're starting at the beginning, I always like to go back to the very basics, and we want to build it correctly. So for people who are watching this or who watch it in the recording later, you may already have a family farm or a business in place. And so we're going to talk about how you can go back and make sure that that foundation is what you need it to be. If you're listening to this and you don't have a business yet, we're going to talk about how you can put the foundation in place that will help build a strong business that will last through future generations. So step one deals with formation. So like I said, a lot of our family farms in our surrounding area are really businesses, and they're treated like businesses. And whenever I'm meeting with family farms or the farmers that are involved in the farm, I always like to talk about the fact that In order for this to be a successful operation, you really do need to treat it like a business. So if you're treating it like a business, then it's easier, I think, to make sure you're maintaining the formalities that you need. So the first thing that you need to do when you have a business, or even if you already have a farming operation or business, this is the first thing you need to do. You need to go to the Pennsylvania Department of State. So if you open up your web browser and you type in Pennsylvania Department of State, you'll go right to the Department of State webpage. Across the top, there are some tabs, and you can click on the tab that talks about businesses and charities. And you want to click on that. And when you click on that and you go to the page, it allows you to search for a business. So if you already have a business, I would encourage you to type in what you think your entity's name is and see if you're registered with the Pennsylvania Department of State. If you aren't registered and you're looking to create a business, that's the first thing you have to do. You have to look to see if whatever name you want to use is available. So whether you're a farm or whether you're a small business, that's the first thing you need to do. I have met with so many clients who have a business and either aren't registered with the Department of State, or when they search their entry with the Department of State, they realize that there are all kinds of mistakes. It could be that the officers have changed. It could be the principal office is different now. It could be that you need to change a couple of different things. So if you're creating a business, you have to check to see if your name is available. If you have a business already, you need to still search for your business, and you need to make sure that everything that comes up on that business page related to that business is correct. If you are creating an entity and you need an address, the principal office, it cannot be a P.O. box. It has to be a physical location. The Department of State doesn't recognize P.O. boxes when you're registering for a business. Now, I have clients who have already registered years ago, and they do have a P.O. box, and that's fine. But now, today, if you're creating an entity, you cannot use a P.O. box as the primary or principal office. So go to the Department of State website, look to see if you're registered, or if you're creating a new entity, look to see if the name is available. We, here at our office, we're just working with a client where they were setting up a business, and we had to check the name availability, and we had to alter the name because if it's too similar to one that already exists, then you have to get consent from that business. So that's why you want to make sure your business is registered, so that you can secure that name for you. But you also want to make sure that you have the principal office correct, because one of the things that you're doing when creating this entity, and we're going to talk about this later, is you're trying to get some creditor protection. And one of the ways that you ensure you're getting creditor protection is it has to be registered with the Department of State, because if you have a creditor, that's where they go to be able to find the address of the notice requirements they have to provide. So if you're looking at it from an entity perspective, to ensure that you're getting that creditor protection, you have to uphold the formalities of a business. And that includes having an address where creditors can send a notification if there's a claim outstanding. So that's the first step in formation. The second step is you may need to obtain an EIN. Tammy and I are administering in a state where it was a small business and it was a Schedule C business, which just means it was the sole proprietor. There was no EIN. So they'd registered with the Department of State, but they hadn't obtained an EIN because they were just going to report it on their 1040 as a Schedule C asset. You're allowed to do that. But the issue is that when this individual passed away, it does make it harder to be able to transfer the business because it's all tied to this individual's social security number, which you can't use when someone passes away. So more and more, we're encouraging our farmers and our small businesses to register with the Department of State, obtain an EIN, and file a separate entity return, because it does make it easier when you're transitioning it to the next generation. So you need an EIN if you're filing a separate tax return, if you want to make it easier for estate administration, if you are going to do an S corporation. So if you're going to set up as either an LLC or a partnership or maybe a corporation, but you want to elect S status, which is a pass-through status. It just means that you get the protection of a corporation, but you're taxed as a pass-through entity. A corporation normally has double taxation. So if you elect S corporation status, it's beneficial for tax purposes. So it's helpful to have an EIN. Third step would be to execute governing documents. So number 3 is always the sticking point, because a lot of times I meet with clients who already have a business, it's been created for years, and maybe they have a governing document. This would be articles of incorporation if you're a corporation, certificate of organization or an operating agreement for an LLC, and then a partnership agreement and a certificate of partnership if you are a partnership. And I've noticed one of two things: either people don't actually have something in writing, or they may have something in writing, but they haven't revisited it and updated it based on what their actual circumstances are. So I'm working with a business out of Altoona that has quite a few assets. It's worth a couple $1 million. And the issue is that they haven't gone back and updated their articles of incorporation. So we're now second generation, and people own different interests. They want different rules to apply. So we're going back, revisiting the document, amending it, and making whatever changes. So you need to make sure that you have good governing documents in place. The other thing the governing document is important to do is that you can get some long-term care protection if you include certain provisions in the governing document. So you want to make sure that if you're working with an attorney, that they're looking at it from the perspective as you age, does it offer some protection against long-term care costs? Fourth thing you need to do is you need to make sure to change officer. So if you get on and you're already registered, you have the Department of State filing, you can see it on screen, but you notice that the officers are incorrect. I dealt with this with a business here locally, that what came up on the screen, those people had actually predeceased years ago. They had different owners, and so we needed to change the officers. So the principal office you change was just filing with the Department of State, but if you need to change the actual officers, that's through the Department of Revenue. So you need to make sure you're doing that. And then lastly, you do want to make sure you're holding annual meetings. So the thing is that only corporations actually have to have annual meetings. But we always encourage our clients to hold annual meetings, even if you're an LLC or a partnership, to show that formality. Plus, you're usually meeting with your accountant or tax preparer once a year anyway. So if you can just, after that meeting, document that you met with the accountant, that you reviewed the financial statements, that you're maintaining the same officers, that you aren't making any changes to the business, and sign and date that and keep it as part of your corporate records, that's more evidence that this is a separate entity, that it's not you as an individual. This is an actual certified entity with Pennsylvania, and that gives you some credit or protection. So these 5 steps are so important when you have a business. And here in our office, we can help you register, we can help you update if you need to, but just remembering that you have to do these things is really important. I may have meeting with clients where they have an entity set up, another attorney helped them set it up, but we go and check all of the registration information and it's incorrect and it's never been updated. This is something that's actually easy to do, but is vital to keeping it as an entity and keeping those formalities. So that's step 1. Step 2 is once you have an entity, either you're creating it now or you've had one and now you're looking at what's the next step. The next step is addressing any estate planning concerns. So you would not believe how many times I meet with farmers or other businesses. Today we're focused on farmers, but for example, let's say we're talking about my family. So if my dad has another person that's farming with him, whether it be his brother or maybe, one of my sisters and their family is going to be part of the farming operation. So often I meet with them and I say, well, what would happen if one of the farmers or one of the owners would become incapacitated and couldn't make decisions, couldn't sign documentation, couldn't do what they normally do? Then what happens? So most people understand that you need to have a financial power of attorney for your personal documents or your personal assets, I should say. So, who has access to your checkbook, who can write checks, who can deal with your personal finances. Think about that in the business setting, though. If you have a business partner, you should probably have a separate financial power of attorney that allows that business partner to do anything that they would need on your behalf if you're incapacitated. So a lot of times we're dealing with multiple owners, and of course they have personal assets and then business assets. So they may have a personal financial power of attorney that says dealing with my personal finances, I might want my spouse or my child to do it if I can't. But when we're dealing with farmers or businesses, you may actually need your co-owner or the other farmer or the other family member that's in the operation with you to actually be in charge of that. And you can either do a separate financial power of attorney, or you can have a specific paragraph in your personal financial power of attorney that distinguishes that if it's related to the farming operation or related to your business, that this is the person who has those powers. So I always encourage, it always comes back to those powers of attorneys. I always encourage farmers and business owners to take a look at that and make sure that they don't need to do something more or different there. Second part, dealing with estate planning. So the first one is if you're incapacitated. The second one would be what happens if you die. So it could be that if you have a governing document like bylaws or operating agreement or a partnership agreement, that may already be addressed in those documents, but 9 times out of 10, it is not. There's no mention of what happens at death because the assumption is that it goes through your will. And you have to think through, do you want that to actually happen? So that business I was talking about out in Altoona, there are 3 brothers who are involved in that. And they have to think through, do they actually want it to go through their will? Do they want it to go to their spouse and their kids? Or does it really go back to their surviving siblings? And so we have to address that. Now, you can either address that in a separate buy-sell agreement, which is my preference, to actually have a separate agreement than the operating agreement. You can address it in the operating agreement, and you can also address it in your will. But you have to make sure that all of these correlate with each other and that it's not, the documents say different things. So you want to make sure that it's a common message or a common theme throughout all the documents, and you want to make sure that you're using the appropriate document that you need. So it could be a buy-sell agreement. It could be that there are provisions in the operating agreement that address it, and it could be that you need to include it in your will or in your trust. And it could be a specific bequest to an individual. And then the question becomes, are they receiving that without having to buy it, or is there a buyout that's happening? And so when we're talking to farmers, a lot of that deals with, is this a family member or another co-owner that's been involved in the business, and should they have to buy it? You know, are we trying to create a stream of revenue for the spouse, a surviving spouse? So we have to talk through those issues. And then if it's going to be a buyout, we have to talk about what are the funding mechanisms. How is this being funded? Is it going to be life insurance if it's a buy-sell? Is it going to be assets in the estate are used to purchase? How is that going to work? And we want to make sure that we are aligning this not only to make sure that it gets to the person you want, but that they receive it in the most tax efficient way. They pay the least amount of taxes and they get the highest basis they can get. So there's a lot of moving parts with this. And I always encourage businesses, farmers to all come together and have a meeting with an attorney to discuss this so that you can make sure everybody's on the same page, and hopefully that attorney can then address it in the business documents. So that would be step 2. So first is make sure the formation is correct. Step 2 would be addressing any estate planning concerns. And that includes what is a succession plan. So we have farm succession plans. We do them all the time. And it is like a business succession plan, but these are specific to our farming families. So we just have to address the way in which it's going to pass from one generation to the next, and specifically that farm. Now, usually there are 2 components of the farm. You have the real estate, and then you actually have the functioning farm or the operating farm. And so being able to address those 2 things separately, but then making sure that we are addressing them together is the way that the farm succession plan needs to be approached. So why is this needed? Well, it's needed because if you don't have it, it's like if you don't have a will. So if you die and there's no plan in place, then really what you're saying is, that's fine. I'm going to let the state decide what happens to my farm. And you don't want to do that. So what you need to do is you need to determine what you want and then plan it. So what you need now, what you need as you age, and where you want it to go at your death. You want to make sure you're selecting the future decision makers and operators of that farm. And you want to make sure that you are setting it up that if you want to maintain either in the family, or if you want to maintain it with those other co-farmers, that the plan is addressing that in a reasonable and feasible way. And then lastly, we want to make sure that when we are creating a farm succession plan, we're providing for that surviving spouse or the family. When we're dealing with farmers, this is the biggest asset in their estate is their farm. And so if we don't address this in a way that provides support and funding to the surviving spouse or family, a lot of times there's nothing in the estate when that farmer passes away. So we really have to treat this very delicately and make sure that we're addressing all the concerns. So why is it needed? We need to facilitate, reduce, create, and address. So we need to facilitate a smooth transition. We need to reduce the emotional impact on the remaining family. We need to create a feasible method of transition, which just means you need to outline the terms of the transition. So what's the value and what's the time period? An example is I'm working with a financial advisor for a farm succession plan, and we have a situation where one brother did not want to be a part of the family farm. So in that case, what we're doing is we are creating the trust to have the primary residence, which is not related to the farm, go to the brother who's not involved in the farming operation. And then we have the farm going to the other two brothers who actually run and operate the farm. And when I was talking to Mom, she's the one who's creating this succession plan. One of the things she said is, I want this to go to my sons who have devoted their life to the farm. However, if they decide at any point that they want to sell this farm, then at that point, I do want my third son, who isn't part of the farming operation, to be able to receive a share of those sale proceeds. Because what she's doing is she is providing a specific bequest in the trust that says that this goes to them. And in reality, if they sold it on the open market, it would be worth over $1 million. But she wants to direct it to those sons who have put their sweat and tears into the farm. But she also wants to protect that, she's giving this $1 million farm to these two sons. She wants to make sure that if they sell it, that third son is still going to get the benefit of it, if that makes sense. So she wants to create a transition that allows, if they're going to continue to farm, that they do get a break in having to buy it out. But if they then turn around and sell it, she wants her third son to be able to share in those sale proceeds. So we're able to do that. That's part of the planning that we're doing for her. We're putting it in a trust, and we have a table that says, depending on what year, if they would ever sell it, that determines the percentage that they have to share with the third brother. So you want to make sure you're addressing those concerns. And then you also want to make sure you're dealing with any tax issues. So the goal should always be to minimize the taxes or to make it so that it's tax neutral. So how do we do that? So let's go over some tips. So tip number one is to pinpoint the goal. So what is the purpose of this farm succession plan? What are we wanting to accomplish? So usually when I have the initial consultation, I'll sit down and I'll say, what are our goals? And I'll actually write down the goals. Here are the goals that most people say. So they want to avoid taxation, they want some creditor protection, they want to do some income tax planning, and they want to create a lasting legacy for the family. And as soon as they say the lasting legacy for the family, my mind does tend to go to using trusts to do that. And I'll explain why later on when we get to the examples. So here are the goals that most people say they have. So identify the goals would be tip one. Tip two would be keep an eye on those taxes. So does the plan minimize the tax or keep things tax neutral? So we always have to keep in mind the 5 types of taxes. In Pennsylvania, we have inheritance tax, which some states don't have. So we have the federal estate, the federal gift, income, we have the healthcare surtax, and then the one that some states don't have to deal with, but we're blessed here in Pennsylvania, is the inheritance tax. So avoiding federal estate taxation, right now the exemption is $11.7 million. So right now we're not as concerned, but we know that President Biden, when he was campaigning, had really advocated for lowering that exemption amount. And if he lowers it, his proposal is to lower to 3.5 with a 45% tax rate. And so that may affect family farms. We have some farming families in this community when you combined all of the real estate. that they have. They have several hundred acres. They may have a federal estate if the exemption drops. So we have to keep an eye on that. And the plan has to be flexible enough that if that exemption drops, that you can do additional planning if you would need to. So you want to make sure that you're minimizing the tax, and you want to make sure that whatever plan you're putting in place is flexible so that if the tax changes and we're dealing with a different tax structure, those farmers can react to that appropriately. So we're going to talk now about the family farm business exemption and Pennsylvania inheritance tax. So I have noted on here the income tax and the creditor concerns. We're going to get to those a little bit later, but Pennsylvania does have a nice exemption for family farms. And I wanted to take a couple of slides just devoted to that before we go to the creditor protection tips. Okay, so let's do that. So 2012, Pennsylvania passed a farm exemption. It's the business of agriculture exemption. And when it first came out, it was a little confusing as to how this is going to be implemented. But now we're a few years out from it, and so we're actually seeing how it works. So it's effective for estates where the decedent died after December 31st, 2012. Interestingly, I have had situations where the attorney who prepared the inheritance tax return wasn't aware that this exemption came into play. So we've gone back and amended those inheritance tax returns to reflect that there is no tax. So know that if somebody in your family passed away previously and it was after December 31st, 2012, that you can go back and now claim this exemption, which means it's not subject to Pennsylvania inheritance tax. This is a huge deal. Pennsylvania has an inheritance tax on your right to receive assets when someone dies. The rate at which you pay the tax is based on your relationship to the person who died. So if you're a direct lineal descendant, child, grandchild, or if you're a parent, if you can go up or down that line, then it's 4.5%, it's 12% for siblings, and it's 15% for everybody else, and that includes nieces or nephews. So this exemption is huge for farmers because they may have a lot of real estate, but they may not have a lot of liquid money to pay the tax. So it does have to be a transfer to members of the same family. So my dad passes away, the farm has to be coming to my sisters and I, a direct lineal descendant, so it can go to a grandchild. It could go to a brother or a sister that he has, or if he had any ancestors living, it could go there. So it has to be a qualified transferee in order for you to meet this exemption. It does now allow trust. So when this first came out, because I love trust so much, one of the first things I wondered was, what if this property is in trust? Because we do a lot of trust here for asset protection purposes. And does that mean we won't get the exemption? And Pennsylvania did come out and say, no, this is going to apply whether you receive it outright or whether you receive it in trust. As long as all of the trust beneficiaries are qualified transferees or qualified family members, then there's no tax, no Pennsylvania inheritance tax. The requirements for this is that it has to be devoted to the business of agriculture at the time the person dies. It has to be transferred to members of the same family of the person who died. It has to be continue to be devoted to the business of agriculture for 7 years after the decedent dies. It has to produce an annual gross, not net, gross income of at least $2,000. And the real estate has to be reported on a timely filed inheritance tax return in order to be able to get this exemption or qualify for this exemption. So what does the business of agriculture mean, and what's the documentation that you need? So Tammy and I were excited when we had a farmer that passed away. Not that he passed away. We were excited we got this exemption because the son, in this case, that's a huge deal. No tax. Doesn't have to worry about paying that tax. So we were excited that Pennsylvania had this exemption available. Now, what we had to do is we had to file a separate schedule that went with the Pennsylvania inheritance tax return, and I had to offer an explanation as to why I was claiming the exemption, and I had to provide, what were they using the property for? In this case, it was for grazing pastures for the cattle, the herd of cattle they had, and it was used to make hay. So I had to explain that. And then I had to explain the income amount that it would generate. So That was all on the inheritance tax return. And then every year for 7 years, there's an annual certification. So, we got an email in January that they had received the certification. They had to complete that and then return it by February 15th. And they will continue to have to do that for 7 years after dad passed away in order to continue to comply with this exemption. Interestingly, there are actually two farming exemptions, though. There's the business of agriculture exemption, and then there's a farmland exemption, and I have them noted there in the statute. Interestingly, the business of agriculture applies to the land and the building. So in the one that Tammy and I did, it was some acreage. It would be, let's just say it's 20 acres or 100 acres, whatever it is, that acreage, and then the barn and any structures that are on that property would be exempt. The downside of the business of agriculture exemption is that you have to file the annual certification. If you apply for the farmland exemption, it applies only to the real estate and not to the buildings, but there's no 7-year certification requirement. So what you would have to do there is when you get your tax card, for example, they may say buildings are this, land is this. So you're going to pay tax on the building portion of it, the structure portion of it. You're going to pay tax on that, but you're not going to do that for the farmland. And so that can be really important if the family is not planning to continue to farm it for 7 years after, because there's no 7-year requirement for that one. So there are these two exemptions. The one that we try to use most if we're dealing with farming families is the business of agriculture exemption, because it applies to the land and the buildings, not just the land. But it does mean that 7-year certification. If for some reason you don't file the certification, or if in the 7 years you sell it to somebody who's not a family member, or if you start farming, the downside is that you have to pay the tax plus the interest and penalties that have incurred from the time you should have paid the tax. So let's say we're near 4 of the 7-year period and child sells it. Then that means they had to pay the original tax that was due back when they received it, plus the interest and penalties that would have accumulated through the 3 years. So you have to make sure that the family is going to be committed to continue to do this. Tip number 3, you want to consider an entity. So the example I told you about the Schedule C, the sole proprietorship, it would have been so much easier if that was actually set up as an entity with a separate EIN and filed. Maybe the accountant filed a 1065 for an LLC, or maybe they filed the corporate tax returns, a separate return. That can actually do 2 things for us. The first is that it does give you some creditor protection. That's why I have the pictures of the little fences there. But it also, if you're going to have if this is a family farm and you're going to have multiple family members involved, having it in an entity centralizes the management and then allows for certain discounts when you're valuing that entity. So if the attorney drafts the documentation correctly, you can get a lack of marketability discount and a minority interest discount, which means that when someone passes away, or if somebody is transferring it, buying it or selling it, and they want to do it at a lower value, the benefit is they can take a discount on what the entity is actually worth, because if there are provisions in there that says that when somebody dies, it has to go to these people, or they have the first option to purchase it, then the way the IRS looks at that is that it's not as marketable if it were just an entity that didn't have those restrictions. So creating an entity, transferring the farm into that can actually be helpful for 2 reasons. It can lower the value if you're trying to be doing some planning for gifting purposes with the federal exemption, and it also can provide some creditor protection, and then it is easier to administer. So how do you do that? You can create an LLC or a family limited partnership, transfer the assets in, and then you can gift portions of it. So for example, for my dad, if he wanted to slowly transition the farm to my sisters and I, he could put the farm, the land, everything into this LLC, and then every year gift 2% to my sisters and I, so that he is still in control of it, but he's slowly transferring that farm over to his kids over a period of time. That's called pattern gifting. And you do that so that you can do it slowly, so that the transition can occur at a slower pace and you can kind of educate and bring on the next generation. It's also helpful for gifting purposes, because then what you're doing is you're gifting a 2% interest of the farm, which might be $15,000 or less, which means you wouldn't have to file a gift tax return and there's nothing that you would need to do there. So an entity can help for gifting purposes. So I wanted to make sure people knew that. Creditor protection, an entity can help with creditor protection. So Pennsylvania has a statute for partnerships that just says that the only recourse when we're dealing with a family farm or a business where it's owned by an entity and there are multiple owners, is the only thing they can get is a charging order. And a charging order just means that if I transfer real estate into a partnership and somebody tries to sue that partnership, they can't get at the real estate. They can only get at any distributions that are coming out to the partners. So it creates some creditor protection for those partners and those farmers that are doing business together. Then we have a court case that allows that for an LLC. So that's where you get that protection. So when we're talking about reasons that you want to use an entity, one of those is creditor protection. And so I'm just providing the background as to why you get that. Tip number 4 is timing is everything. So what people most often do not address in their governing document, in their bylaws, operating agreement, partnership agreements, what happens if somebody dies or what happens if somebody is disabled. I had mentioned earlier, if you have farmers and you have them in different generations. So we did a farm succession plan for dad and his son. Dad's in his late 60s. The reality is if dad goes into a nursing home and he still owns the real estate of that farm, that is an available resource, meaning a nursing home could force the sale of that farm to pay for dad's care. So we want to make sure that we're protecting against disability long-term care costs. And you can do that by including that in your operating agreement, making sure you're addressing the fact that it's not an available resource for long-term care, and then looking at using trust as a way to protect, which I'm going to get to in a second. You can have the first right of refusal or an option to purchase at death or disability as well. So these triggering events can either cause something to occur, whether it be a buyout or a transfer, or it could just be that you're isolating it and saying that it's not available if somebody would need long-term care. You also want to make sure you're addressing bankruptcy or divorce. If one of the farmers would get divorced, how is that going to be handled? And is the triggering event mandatory or optional? So in the situation with father and son, if dad goes into a nursing home, is it just that son has the option to purchase it? Or is it at that point, it is a mandatory, the son has to buy it? So you want to make sure you're addressing, is it mandatory or optional? And you want to make sure you're updating those governing documents to address that and include that. And I don't think I have seen one yet that actually the farmer comes in with their governing document and they actually already have it spelled out. I've never had a case where that's happened. Normally we're amending it so that they're addressing it in the document. So types of succession plans. You can use trusts. You can do a gift through the last will and testament at death, and it can be part gift, part sale. You can deal with it that way. You can do pattern gifting annually. So again, if my dad transfers the farm into an LLC and then is gifting me 2% every year, you can do that. You can have a buy-sell agreement, and you can make it cross-purchase, which just means when one owner / farmer dies, does the other farmer purchase it from them? Is it that the entity acquires that deceased owner's interest, or is it that you have the option? At first, somebody can offer to buy it, and if not, then the entity then purchases it. The first one, dealing with trust, I love trust so much as it deals with family farms, and that's because it allows the farm to be protected. You get the same protection as you would in an entity, but the difference is that if you transfer your family farm to a trust, there's not the realty transfer tax that applies to entities. So if my dad would have farming real estate that he would want to be transferring to me, he could actually put it in trust to me, without transferring it into the entity. He could transfer it into trust, and there's no transfer tax that applies. If he decides to set up an LLC or a partnership and he transfers it into that LLC or partnership, there's going to be a transfer tax, a 2% transfer tax that applies. And he's going to have to pay that now. And so a lot of times we're able to get the same thing done using trust as we would with an entity. It's just that a lot of times people don't think of trust in that realm, but you can absolutely use trust. They offer fantastic creditor protection. They offer some great tax benefits there. and we don't have the transfer tax that we do with an entity. So I always encourage people to use trust to the extent they're able to help you. The other thing it does is, in the example of if you have a family where some people are committed to farming and others are not, but you want, if the farm is ever sold, to be shared among everybody, a trust will allow you to do that. If you just have it paid out in a will and it goes outright to your kids, 10 years down the line, if the farmer sells it because he's no longer going to be farming, then they get 100% of the sale proceeds, where you may have said, no, when I die, I want it to go to my farming son, but if he would sell it, then I do want the sale proceeds to be split. Or, the sale proceeds, a certain percentage to go to the child that wasn't part of the farming operation. And a trust, you can do that. You can create those restrictions. You can also say if one farmer wants to sell, they first have to offer it, and these are the conditions under which the sale occurs. You can stipulate the value. You can say you're going to use the tax assessed value. You can say you're going to use an appraised value. There are a whole bunch of things that you can do in the trust that you can't do if it goes outright to the other family members. And then tip number 5 is consider asset protection planning. And we're seeing this more and more, where as people age, they may need long-term care. And they may not realize that if there's real estate that they're farming, that real estate is available if they would go into a nursing home, meaning that the nursing home could force a sale of that real estate if that individual uses all of their other assets. And again, with farming families, sometimes you see where they are land rich and cash poor, so that's a big deal. So you can protect the real estate and an entity. So if you already have it set up in an LLC or a partnership or a corporation, or even if you don't, and it's just the real estate, you can use a trust to do that. And what it does is it protects all parties. So if you have multiple generations, if you have father and son, what that does is it ensures to son that if dad ever needs long-term care, that the farm will be protected and would not be an available resource for dad's care. So using a trust is a great way to do that. Now, the downside of the trust is you have the 5-year look-back period. So what we're trying to do is we're trying to educate people so that they know the sooner you do the planning, the more likely it is that you're going to get the protection. So we're working with a farming family where they didn't have an entity. It's actually 3 generations of farmers. So we have grandfather, son, and then grandson. Yes, grandfather, son, grandson. So the 3 generations. And grandfather was recently diagnosed with dementia. And son and grandson came to me and they said, what can we do to protect this real estate? And what we did is they didn't have it already created as an entity. They just owned the real estate 3 ways. Over the years, they had transferred it so that grandfather, son, and grandson's name was all in the deed. And so what we did there is we said, okay, maybe we want to take grandfather's interest and we want to transfer that into a trust so that if grandfather's condition continues to decline and would either need skilled care, would need somebody coming into the home, or would need to go into a facility to get that care, the property is not available to pay for the care. So grandfather would use, other assets that aren't transferred to the trust. And then if he spends that down, then Medicaid would step in and start paying rather than jeopardizing the farming operation. So this is huge. And in this case, the family didn't know that was an option. And so they came in actually to find out if they should set up an entity or what they needed to do. And so we started talking about the long-term care. We talked about how this was an option. And we talked about how, not only should grandfather do it, but dad, who's in his early 60s, might want to do it as well. Because think about this. Dad can set up the trust, can transfer the asset in, start the 5-year look-back period now. And inside the trust can say that it's still dad's. He's still going to be in control. He's the trustee. He's going to own it, but it's going to be protected against his long-term care after it's been owned for 5 years. Plus, the trust can say at dad's death, this is going to son. And it can either go outright to son or maybe it goes in trust for son if we want to protect son against divorce, car accidents, any other creditors that they may have. In addition, dad can then say, well, I want it to go to son in trust unless he's going to sell it. And then if he's going to sell it, then I want him to share the sale proceeds with his sister. And in that case, again, it's not 100% of the sale proceeds, just a portion of it that he would have to share if he sells the property within 10 years. So we were able to accomplish long-term care for dad, creditor protection for son, and then also have a buy-sell in that trust. So we accomplished everything with just one trust document. We could deal with it all in that trust document. And so it was a great way. It was cost efficient because they didn't have to have all of these other documents. And it really gave them peace of mind to be able to do that. And so I really encourage you to consider that option, to do the planning early enough that you can address that. And, if we needed to, we could have done multiple trusts for multiple generations, and then you can have similar provisions in it. So if we're talking about two brothers that are farmers and they want to set up a trust, and, you don't know who's going to be of the next generation is going to be wanting to be a part of it, you can put in the trust that, it's going to these children if they happen to be farming, but if they're not farming, then you can actually say the trustee can offer it to the other trust. There's so many neat things that you can do to get the asset protection, to get the creditor protection, and create a succession plan all within the trust. Doesn't mean you have to use a trust. You can still use a buy-sell agreement and the operating agreement, but you can do it all in the trust. And so it's nice to be able to provide that option for clients. If you decide not to use a trust, you at least need to include something in the governing document talking about whether or not this ownership interest is available for long-term care costs. And we're not saying that that's going to absolutely protect it, but what I can tell you is that if you don't have anything in the document and somebody needs long-term care, then that asset is an available resource. If you have put it in the governing document and it's been in there for years that is never going to be available for nursing home costs, either it's going to trigger a buy, sell, or it's going to revert back to the other owners, then there's a greater likelihood that you can argue it's not an available resource. The best way is still using the trust or using some sort of long-term care insurance or something like that, but at least it gives you one additional layer of protection. We talked about the financial power of attorney. So again, even if you don't do a trust now, you want to make sure that either in your personal, if you're dealing with farming operations and you're saying, I'm giving this specific person the ability to handle my farming operations, you want to make sure that you're also allowing that agent to be able to create a trust and make transfers if they would need to do that. So whether it be you're using one power of attorney and you're distinguishing between personal and business or farming assets in that one document, or whether you're doing a personal and you're doing a farm POA for that business, you want to make sure that you have the power in there so that if you would ever need to protect assets, you could do that. And then this is just a picture of the trust that we use here in our office. And I wanted to bring this up. I know we've talked about it a couple of times, but I wanted to give you an example. So let's take my parents. So Denny and Denise, just so that it's easier for me to refer to them. So if, dad's thinking he wants the farm to go to the next generation, he can create a trust, and he and my mom can still be the trustees, which means that they're still in charge of it. If they want to sell it, if they want to sell and downsize, they're the trustees and they can still do that. They still have the control to be in charge of the asset. What they can't do under Pennsylvania law is they cannot have the ability to reach in and pull assets out of the trust, but they can have us do that for them if they need to. So think about this. If mom and dad put the farm in there with the thought that they're not going to sell it or do anything, and then if they do, that's fine. So let's say they sell it, they downsize, and there's $200,000 worth of assets. Mom and dad, as the trustees, can either take it and invest it, or they may say, Sam, we need you to pull out $10,000 because we want to buy a new car and we want to use cash to do it. They can't reach in and pull the $10,000 out, but they can ask me to do that. And if I tell them no, they can fire me and appoint one of my other sisters to do that. So there's a way to get assets out of the trust. And if you have an entity, whether it be an LLC or a partnership, you can actually assign the entity into the trust, and that gets protected. And then if you want to have access to the income or the draws or distributions you're getting out of it, you can have the trust say that. But if an LLC owns the real estate and you throw it into a trust, then what that means is that you're protecting the real estate and you can still have access to any distributions or income generated off that partnership or that LLC or that farm. So this is a great way to do it. And then my parents can say that upon both spouses' deaths, it goes, in trust for my sisters and I. They can say the farm goes to this particular child, or they can say it goes to this particular child unless they sell it. So the trust just allows us to put all kinds of flexible restrictions, as well as providing the restrictions that my dad would want for those future generations. So trusts are a great way to do that. And I know I'm talking a lot about trusts as opposed to the entities. The reason I'm doing that is I don't think that there's enough information out there about the trust and how they can be used. I think everybody understands the entity and understands how that's helpful. And I'm a proponent of using the entities. But I also think we can use trust in conjunction with the business entity too, to provide further protection for that real estate. Next month, we are shifting a little bit. So instead of talking about farms and businesses, on April 8th, we're going to talk about how to protect that special person when they can't protect themselves. So this is really about how to protect a child or a family member that has special needs. We're going to talk about how do we do that? How can we protect assets for them? So that'll be April 8th. It's at noon, just like all of our monthly seminars. We will be recording that, and then we post it, of course, on YouTube and Facebook. You can register for that seminar by emailing Amy, or you can call us at 717-655-2676, and you can just tell Amy that you want to attend it, and she'll send you the link and send you reminders and all that good stuff. And then the last thing I wanted to mention is that, of course, after everyone, we always send a link for a survey. We do appreciate any feedback. I do have to say that we've had some great surveys in that people are putting what they want. So, for example, today we're talking about family farms, which was a suggestion. And one of the upcoming months, we're going to talk about first steps. What do you do? What are the first steps in all the different areas? So when someone dies, for estate planning, we're just going to focus on the first steps. We're going to focus on rental properties. 1 month that someone had requested, and we're going to focus on Medicare. So we do have our seminar scheduled through August, I believe, now, with everybody's great suggestions. So we do appreciate that. So always feel free to give us any feedback that you have. And now I'm going to take questions. So what I'm going to do is I'm going to stop sharing my screen, and I am going to stop the recording just so that anybody can feel free to jump on and ask any questions that you might have. So I'm going to go ahead and stop the recording.